Thank you for joining us for this episode of the Real News Extra. My name is Fred. I am the Operations Manager here at RELAW APC, and joining me today is Jennifer Felton, the Principal and Founder of RELAW APC.
Hello.
So Jennifer, the U.S. Supreme Court recently made a determination on the Federal Arbitration Act, FAA. What was their decision, and how does this change the discretion that federal courts have in arbitration cases?
So it's really important to understand that the Federal Arbitration Act has created a framework nationally of how courts can and what states can do relative to arbitration. It creates an obligation nationally that if a parties agree to arbitrate, they're bound and allowed to do that, to use that alternative system to the courts. So the case in question involved a situation where a lawsuit was filed by one party and the other party said, oh, we're bound by arbitration. And so the court ordered the case to go to arbitration. The court then dismissed the original lawsuit because it was going to arbitration. The case law and the statutes were inconsistent relative to this issue. And so the plaintiff who had filed the court action said, I think the court screwed up in dismissing my case. And it went to the Supreme Court and they agreed. The position they took is that the Federal Arbitration Act requires an arbitration be stayed, not dismissed.
Got it.
The case that's supporting it while the arbitration is going on.
So how does this decision impact both the plaintiff and the defendant in an arbitration case, in particular, in order to be able to get back into federal court if the arbitration does actually fail to resolve their dispute?
So arbitration does result in a judgment, but it may not resolve all of the issues in a case.
Got it.
Because within that arbitration, the scope of the contract determines what can be decided and what can't. So the arbitrator may not have authority to deal with all of those issues. So even when you get an arbitration award, you may need to still go to court, not only to get other issues decided, but also to get that affirmed, to try and get a judgment. So there's a whole bunch of things. So this case allows and forces the court to keep that case open and going, to hopefully streamline, that's a bad word for court, but hopefully keep the judicial process moving forward so that we're not having to go to court multiple times over the same thing.
What are some of the implications this decision has on both the viability and the benefit of having an arbitration clause in a contract?
Well, most attorneys like me are not big fans of arbitration, and my concerns around it revolve around the fact that an arbitrator has very broad discretion to make a decision as to what is going to happen in a case. They do not have to follow the law. So as an attorney, I want to know, I want to be able to tell a client, the law says this, so this is how I think this is going to go. When I'm talking about an arbitration, I can say the law says this, but who knows how it's going to go, right? We're going to present our case and we hope that the arbitrator follows the law, but they don't have to. So now that the arbitrations are going to be left open in court, I do think that bodes for a better likelihood of the law being followed and more stability with arbitrations. But still, for someone like me, I'm more likely to want to be in court than in arbitration in most cases.
Understood. Thank you for joining us on the Real News Extra. My name is Fred. I look forward to seeing you on the next episode.